Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. So, unfortunately, the headline of this video is not clickbait. The most recent versions of the Apple Watch will no longer be sold by Apple effective as of the 21st, so 2 days from now, and supply of the Apple Watch will stop coming into the United States from China, where it's built and developed, effective as of December 25th, Christmas Day. So supplies will run out rapidly unless someone can find a solution to this problem. But Apple has already announced their intention to stop selling the product as of the 21st. And we'll get into that. But first of all, we're going to cover a news article about this, which goes into a lot of detail, covers out pretty well what happened. And then we'll get into the patents at issue, because that's my turf. And we can try to understand patent together, because that will be fun. I am, after all, a patent lawyer. I'm an expert. All right. So let's read this. Thank you very much, Alan Parker, for the 20 gift memberships. From 9 to 5 Mac, the news article does a pretty decent job of summarizing this. Apple is halting the Apple Watch Series 9 and Ultra 2 sales, so the latest and greatest versions of the Apple Watch. The move comes following an ITC ruling, the International Trade Court, or International Trade body, which deals with import-export stuff. So ITC is very common in patent matters. It's basically who you go to if you're upset that your product is being infringed on and is being imported into the United States. So they're the people who can order customs to seize the stuff, if they weren't already going to seize the stuff, because, so they can order customs to seize the stuff to prevent, knockoffs from being imported into the United States. So, it's a long-running dispute between Apple and this company, Masimo, over the blood oxygen sensor technology. They've been involved in multiple different disputes relating to this and multiple different lawsuits, and we're going to discuss this ITC action in particular. The Apple Watch Ultra 2 and Apple Watch Series 9 will no longer be available from Apple's website as of 3 p.m. Eastern Time on Thursday, December 21st. In-store inventory will no longer be available after December the 24th. The International Trade Commission announced its ruling in October, upholding a administrative law judge's decision from January. So this is all within the executive branch. The administrative law judge is an executive branch official, and they resolve the dispute within the executive branch because, again, we're talking about ordering customs, right? So customs is within the executive branch, ITC is within the executive branch, and so ITC is the part of the executive branch that tells customs and other people, what stuff to seize, among other things, especially as it relates to intellectual property. So that's how that goes. Of course, you can obviously go to court. You can go to an Article 3 court, but the ITC is a very, very common place where you start, and it's very, very frequent to go to both court and ITC because you can do both at the same time. This, of course, sent the issue to Biden, who, as the chief executive, can change what the executive branch can do. So Biden has the power to overrule this because he's the chief executive. So he obviously is in control of both customs and the ITC. So he can be like, yeah, we're not doing that. But, he hasn't done that yet. So they say veto the ruling, although that's not quite correct. It's neither a veto nor a ruling, strictly speaking, but never mind. The presidential review period expires December 25th, and Apple is making the announcements to preemptively take steps to comply with the decision because I think they're afraid that Biden won't step in because he hasn't, in related cases. But he could, but he probably won't. I mean, it's not, the end of the world. It's inconvenient. It's not great, but it's, not banning the phone. It's banning the watch. So probably won't step in if I were a betting man. The Apple says the ban only impacts the sales of the Watch Series 9 and the Ultra 2 because only those have the blood oxygen monitoring capabilities that are at the end of this stuff. The Apple Watch SE will be unaffected by this and will remain for sale. The ITC's decision only prohibits Apple from selling the products, but as I mentioned, it also is an order to customs. So while, Best Buy and Amazon can sell their stock of what they have, Apple can't sell it because they're directly prohibited, so they can't sell it. And why Best Buy and Amazon and whoever else can sell it to you, they won't be able to get any supply because, they can't be imported. So that's a problem. So yeah, so it will ban importation after December 25th. So yeah, Best Buy and Amazon can't really sell to you either because they don't have it. So meanwhile, any Apple Watch with a blood oxygen sensor that's already been sold is unaffected. So that's good news for you guys. So anyone who already has this thing, you're good. You're not in problem. And also the ruling makes clear that that Apple can provide warranty coverage on their watches, although it's a little bit unclear how they'd go about doing that because they can't import new ones. But to the extent they're actually able to repair them, they can do that. So that's fine. And then Apple provides a statement, which we don't need to read right now. Masimo is a medical technology company that has been embroiled in multiple lawsuits with Apple and center around the blood oxygen sensor technology. First of all, we have lawsuits, including one in California, and then one with the ITC, although those are not necessarily the extent of their proceedings, but those are the ones that are most relevant to our immediate issue. Massimo said it started the campaign with the ITC because it was frustrated by the district court case. Again, not uncommon to do both because either one can give you relief, right? The court decision is obviously going to dominate, at the end of the day, but, the executive, for want of a binding decision by the courts, can certainly try to figure out what the law is themselves. So yeah, going to the ITC, very, very common. In the initial filing, Massimo accused Apple of 103 instances of patent infringement with respect to its watches, but the ITC only found infringement relating to 2 patents, which fortunately makes my life much easier, so we will cover the claims that they found infringing. The ITC handed down an order in October in relation to a decision by the administrative law judge in January. I have a copy of that decision, but it goes on for quite a lot of pages. Trying to analyze this in, precise technical legal detail. So we won't go over that right now, but we'll go over the relevant patents and I can explain it to you. So anyways, they handed down the decision in October. So it gives Biden 60 days to review, which just so happens to expire on Christmas Day. And then they say they can veto the ITC ban, but veto, again, is not quite the correct language, but, it's a news article, so we'll let it pass, I suppose. It is rare for the president to veto a decision from the ITC. I continue to take umbrage at the term veto, but fine. Last time such a thing happened was 2013 when Obama overturned a ban in relation to a long-standing dispute with Samsung. And the last time before that was Reagan in 1987. So it doesn't happen extreme amounts because basically the president is supposed to find, at least what the law says they're supposed to find, is essentially that it's like manifestly against the public interest. And, again, when you're talking about the phone, that's a lot easier of a case to make. This ban would be manifestly against the public interest. I mean, obviously the court can order it in the end, but, the executive doesn't have to do it. And they're like, yeah, this seems really bad, so let's not. And, yeah, but this is the watch, not the phone, so I wouldn't get hopes up. All right, and then they say what might happen to the watch itself. Apple, of course, says the ITC finding it should be reversed. In order to reverse that, they have to go to the Court of Appeals for the Federal Circuit, and they can either get, a stay of the order from the ITC, which I wouldn't bank on, but, they can try. And they can get the decision by the ITC reviewed by the Court of Appeals for the Federal Circuit, to which all the patent cases go, because that's why the Court of Appeals for the Federal Circuit was invented. So all the patent cases could go there. But, the decision is in place as long as it's in place. So until they get that stay from the Court of Appeals for the Federal Circuit, they have to comply, because of course they do. And then Apple talks more about why the watch is great and how it saves lives. and how they think that the company who's done this has done this to launch their own product. And then they say if Apple says if the thing is banned, then the company won't see a benefit because their smartwatch is not a substitute, which maybe it's not. Maybe they wouldn't sell very well, but it is their technology. You know, it is their right. So they have the right to exclude, and they have the right to make, you know, Apple pay through the nose, you know, which I imagine they would want Apple to do because they've got a pretty big boot on Apple's neck. You know, so if I were them, I'd be like, yeah, we'll sell to you for money. How much money, how much cash do you have on hand, Apple? $2 trillion? Okay. Yeah, we're going to want some of that. So we can appeal to the Court of Appeals for the Federal Circuit, and it will not delay the ban unless they can get the stay. The patents in question don't expire until August 2028. So short of a workaround, either in software if they can do it, hardware if they can do it, making some sort of agreement where we write a big ass check, they wouldn't be able to sell these watches or any other watches that infringe on the technology until the patent expires, which is, you know, 5 years from now, and that's a long ass time. There are other paths they can pursue, including settlement and licensing. You better bring a big-ass checkbook, because I have you over a barrel. So it better be a really big number. You can also attempt to design around the patents, either in hardware or potentially firmware, but we'll discuss the degree to which that's possible or not as we review the patents. And of course, there are a lot of unknowns about what will happen in the near future, although honestly, they're more known than the article lets on. You know, your options are pretty limited here. Biden says no. That'd be great. The Court of Appeals for the Federal Circuit issues a stay. That'd be great. Or eventually overturns the ITC. That would be great. Or you somehow redesign it in hardware and or software to get around it. So those are your options. I suppose you could just stop selling the watch, but you know, Apple doesn't really want to do that either. So yeah, I mean, you know, the set of options are not particularly extensive. So yeah. In a statement, Massimo said that the ban sends a powerful message that even the world's largest company is not above the law, blah, blah, blah. And then, of course, separately, they filed lawsuit relating to this in the district court. And the Patent Trial and Appeal Board, for its part, within the Patent Office, has also been trying to deal with this and also invalidated some of the patent or patent claims. So the Patent Office itself also got involved in this because, of course, it does. You know, Apple runs off to the Patent Office and be like, hey, Patent Office, would you like to, you know, undo those patents? And so the Patent Office did a re-exam, and then the Patent Trial and Appeal Board said, you know, 15 of these patents are invalid. We should never grant them in the first place. So, of course, they're appealing that decision. Many, many lawsuits on many, many different fronts, right? We've got actions before the Patent Office to invalidate the patents. We've got actions before the ITC to enforce the patents. We've got actions in the district court. We've got actions in the potentially in the Court of Appeals for the Federal Circuit, right? This is a battle on many different fronts, which is not atypical. Which is not atypical. This is kind of the thing you would expect to see in a patent fight. This is very, very common. And then there's the issue with trade secret. The judge rejecting some of those claims and dismissing them for lack of evidence. And then apparently that some of them were put in front of jury, but with a jury of 7, and they apparently needed to be unanimous, and they weren't. So there was a mistrial. So that is how some of that is going. All right. So that basically is the breakdown of all that. We next turn to the 2 patents in question that were found by the ITC to be relevant to this matter. Out of 103 claims and the 5 different patents, we have boiled it down to, fortunately, a select few that we can work from. And so this is a patent This is what it looks like for those of you who have never seen one before. This, you see the patent number in the top right corner. Date of the patent, 2021, and then you see it was filed September 24th, 2020. So that's the priority date. So if Apple could show this technology was known before then great, but apparently they haven't been able to do that, right? They've only been able to invalidate some of it, not all of it. So apparently some of these claims, including the ITC, believe some of these claims do not have prior art with respect to the particular claims that predates 2020. Again, this is all claim specific. So we have to look at the specific claims and, we'll see this. But basically we have a user-worn device for non-invasively measuring a physiological parameter of a user. Non-invasively, we're not piercing their skin. Physiological, probably blood pressure, pulse ox, that kind of stuff, right? What can we do? What can we do with not, without piercing their skin and stuff like that? Okay, great. And then we have the abstract, which describes the invention broadly. The explain it like I'm a fifth grader territory, because this entire thing is 109 pages. So this whole thing explains it in extensive technical detail, because that's the entire point, right, of a patent. The entire point of a patent is to explain it in extensive technical detail. That's the deal. You give us knowledge, we give you a monopoly. That's the deal. So in order for you to get the monopoly on the thing, you have to teach everyone how to make the thing, right? That's the entire point. So you have to tell everyone how to do it. Great. So it goes into 109 pages of explaining it in fairly extensive technical detail, but the abstract is the explain it like I'm a fifth grader version of it. So, but still in patent language, but it's not too bad. But still, it's written in patent language. So anyways, so the present disclosure, i.e. the thing we're telling you about right now in this document, relates to non-invasive methods, devices, and systems for measuring various blood constituents or analysis, such as glucose. So we want to use lights or sensors or whatever to determine things about your body, including glucose. Great. In an embodiment, which is in a manifestation of the invention, right? So this patent describes basically every possible use case, right? Because that's the whole idea within the scope of the technology. So in some version of that, a light source comprises LEDs and superluminescent LEDs, bright ones and really bright ones. The light source emits light at least wavelengths of about 610 nanometers, about 640 nanometers, and about 1610 nanometers, 1640 nanometers, and 1665 nanometers. Hey, here's the light wavelengths you need to make this work. In an embodiment, again a manifestation of the invention, the detector comprises a plurality, meaning more than one, of photodetectors. They can sense light, arranged in a special geometry comprising one of substantially linear, substantially equal space geometry. They're in a line and they're set apart at equal intervals. A substantially linear, substantially non-equal geometry. They're in a line but not at equal intervals. And a substantially grid geometry. There are multiple of them in a grid. Great. And then we get pictures of their manifestation of the invention, how they perceive this invention being done in the real world. But remember, the patent covers all the technology, not necessarily how they perceive this being done physically, right? It can be done in other ways physically. This is just how they see it being manifested, but they get coverage for all the technology that they have a right to have. So they have what looks suspiciously like a pulse ox sensor that one would put on their finger. And then we see, here's all the prior art, right? So the patent office, in considering this, here's like all the related application data. Here's, okay, so there's a provisional, actually it goes back to 2008. So this all goes back to a provisional in 2008. So 2008 is actually the critical date, apparently. So yeah, this all goes back to 2008. So This is fairly old technology. Not 2020, 2008, because we go back to the provisional dates. All right, and then we see the classifications, then we see all the references cited. Basically, here's all the art that exists, that either the office cited or the applicant cited. Here's all the prior art references that exist. Here's all the other technology that is related to this. And as you can see, this list goes on for quite some pages. Lots and lots of pages, all the pages. Just here's all the technology that exists that's related to this. And then we get into the foreign ones that are related to this, and it just goes on forever. Right? And then we have also the non-patent literature. Because, of course, patents have to be, there can't be prior art, and that prior art isn't necessarily manifested in a patent. It can be manifested in a paper or other non-patent literature. So we go through like all the academic papers, all the books, all the, speeches, all that shit, and that goes on for a lot of pages. Are you beginning to understand why patent law is really, really complicated? Are you beginning to understand why patent law is really, really complicated? Because you have to assess whether this invention is new or not based on all these references. It takes a lot. Welcome to my world. So we have more stuff. And yeah, so the prior art goes on for 20 pages. And all those documents are themselves, dozens or hundreds of pages long. Welcome to my world. Welcome to my world. Great. Then we have a circuit diagram that shows this in schematic form. Schematic form is great. Then we have, how this might be embodied how this might actually be embodied. So we have, some control buttons. We have a display that shows you result, detector, shell, the sensors, monitor, right? So that's how that might manifest. Then here's another version of it, which has it connected to a wire to some sort of pad-like display. And here's another version of it. Here's another version of it. Here's the clip in more detail. Here's the clip in other detail. Here's the clip that shows you the actual sensors and placements. Presumably this is, so the ones that, 322 and 320 are, in a line substantially even apart, but 320 relative to 321 has a bigger gap. You see that? Right? The gap between 322 and 320 is relatively small. The gap between 320 and 321 is much wider. So that's what they were talking about in their abstract, right? Remember, because they said substantially linear, substantially even spaced, and then substantially linear, but not even spaced. That's exactly what they were talking about. And substantially in a grid, that's exactly what they were talking about. So now they're showing you what that looks like. Oh, okay. So we have 322 and 320, which are evenly apart, but 320 and 321 are not evenly spaced apart, and they're substantially in a grid. Great. So now I have a visual reference of what that looks like. And then, of course, more about the clip and more about the detectors and showing the spacing, which they're going to describe in more details in the written description. These are just illustrations. All these numbers, by the way, all these numbers like 316, 306, 340 refer to things that will be described in the specification. So they'll show, they'll say something like, as in figure 3E with respect to, some 316, and then they'll go on to explain it in technical language. And that goes on and on for quite a while, as you would expect. But these are mostly for illustrative. Again, in figure 4A, we're showing the spacing in a little bit more detail. Now we're showing how the light should be sent at different wavelengths for different purposes and how we're detecting at different points. So we're explaining this in all technical language, right? More about the LEDs. Again, here's some stuff dealing with wavelengths and detection angles. Stuff dealing with noise versus signal and how to deal with noise issues. More stuff about the sensors, technical descriptions, more about the wavelengths, showing, basically showing the components in incredible technical detail. Again, a little bit of a schematic to show how the detectors are associated with each other. So we can see D1 is associated with D2, but isn't associated with D3, but D2 is associated with D3. So you can see how they're associated with each other, but D1 isn't directly connecting to D4, but it is intermediately. So there's showing the sensors again. And we have the anodes, photodiodes, cathodes, the active area. Now we're showing how they emit it with the schematic, emitters, pulses, measurement sites, detectors, front end interface, more about the sensors, showing again, more about the sensors. I told you it's technical. Right? We're teaching you everything there is to know about this. We're teaching you exactly how to build it and how every part works in excruciating technical detail, because that's the entire point. Right? And these are just the illustrations, right? These are just the illustrations to show you. So the illustrations go on for quite a while to show you how, we actually have the resistances. We need exactly 40 ohm, in this resistance. Here's exactly how they're connected. Here's exactly the output. We have an averager here that averages the outputs to show you exactly how it does that, exactly what kind of electricity you need. Photodetectors, braces. Now we're going to show you the clip in even more extensive detail. So this is the finger clip, and now we're literally showing you literally every single part of it. This is exactly how we build it. This is exactly how to build it. These are the components. Yeah. Then we show, again, we show glucose at various levels to show what we're trying to detect for at various things. Scatter plots, more scatter plots. And then we get into the very long, now we explain the entire thing in words. So basically now we're going to explain in words all the pictures. And this goes on for quite a while, as you would expect. And the summary, again, is the closest we get to explain it like a fifth grader territory, right? The summary is as close as we get to explain it like a fifth grader. Maybe more like explain it to a high school student, but yeah. So here's the summary of the invention. This disclosure describes embodiments, in other words, there's multiple different ways to do this, of non-invasive methods, devices, and systems for measuring blood constituent or analytes such as oxygen, carbon monoxide, methaglobin, total hemoglobin, glucose, protein, glucose, lipids, a percentage thereof, the saturation, or for measuring many other physiological relevant patient characteristics. These characteristics can relate to example, pulse rate, hydration, trending information, analysis, and the like. Yeah. In an embodiment, the system includes a non-invasive sensor and patient monitor communicating with a non-invasive sensor. There's a sensor and a monitor that determines the sensor. The sensor may include different architectures to implement some or all of the disclosed features. In addition, an artisan, the person of ordinary skill in the art, the ordinary reasonable, this is now the reasonable man test, except the reasonable man is now an expert in non-invasive ways of determining physiology, or yeah. So it's the reasonable man, except he's a hyper expert. So that's who we're talking about. That's who the artisan is. So this artisan will recognize the non-invasive sensor may include or may be coupled to other components, such as a network. It might be hooked up to a computer. Moreover, the patient monitor might include a display, a network interface for communicating with the computer, a handheld computing device, mobile phone, the internet, or the like. The embodiments may include mobile optical sensors that emit light at a plurality of wavelengths, in other words, more than one. So you need to display multiple wavelengths, and that are arranged from the perspective of the light detectors as a point source. So although we have multiple emitters, the detectors see it as one thing. Great. In embodiment, the non-invasive device is capable of producing a signal response to light attenuated by tissue at a measurement site. In other words, the light has to pierce the tissue, and so the sensor can deal with the fact that it has to pierce the tissue. So it is able to deal with the fact that the light is going to be diminished somewhat by the fact it has to go through the tissue to do all this. The device may comprise an optical source and a plurality of photodetectors. The optical source is configured to emit radiation at least the wavelengths between 1600 nanometers and 1700 nanometers. We're going to use light able at these wavelengths. The photodetectors detect the optical radiation, said optical radiation after attenuation by the tissue of the measurement site, and each output respective to a signal stream. And then they describe other embodiments for some length, which we don't have to read in detail. The summary itself goes on for 2 pages because it's a complicated thing. And then we go into explaining the invention in many, many words. This is the fun part, right? How do you explain the invention just using words? Welcome to my world. Welcome to my world, right? So we go on for many, many things to explain the invention in many, many words with, again, all these numbers in bold, like you see these numbers in bold, are referring to the figure that were previously numbered to show you exactly what they're referring to and exactly what we're telling you about. So we explain that in excruciating technical detail for a very, very long time with formulas and words and all that shit. And finally, at the end of this rodeo, we get ourselves to the claim, right? So the claim is the thing at the end of the day because you can only infringe a claim. And so this is the claim that the ITC found to be infringed by Apple and the watch. So let's read it, right? A user-worn device configured to non-invasively measure oxygen saturation of a user. The worn device comprising, here's what it has to have. But it can have other stuff. It can have other stuff, but it has to have this stuff, okay? So as long as it has these things, it infringes, even if it has other things. But it has to have these things. It has to have all these things. So the infringing device has to have all the things. If one of them is missing, it doesn't count. Okay? So we need to find that the watch does literally all these things. Great. So we have a plurality of emitters configured to emit light, each of the emitters comprising at least 2 light-emitting diodes. That sounds like an Apple Watch. We have 4 diodes arranged within the device and configured to receive light after at least a portion of the light has been attenuated by the tissue. In other words, it has to go through the tissue, so it's going to be diminished. A protrusion comprising a convex surface, including separate openings extended through the protrusion and lined with the opaque material. Each opening positioned over a different one associated with each of the 4 photodiodes. The opaque material configured to reduce the amount of light reaching the photodiodes without being attenuated by the tissue. So the sensors have, shields on them to make sure that the light-emitting diodes themselves aren't fed into the sensor. Right? We want to make sure that the sensor only detects the light that is coming back from being reflected from the blood, right? So we have a little shield of some kind to prevent the light-emitting sources themselves from being detected by the diodes. Optically transparent materials within each of the openings. Well, we're going to need the light to get through the sensor, so it's probably important that we have an optically transparent part too. And then 1 or more processors configured to, and configured to is means for language, where things get really, really fun. That gets really, really fun. So in order to understand exactly what that means, now we have to go back to the spec and reread that, because configure to is means for language. And so that restricts the nature of the invention. And this is where Apple's best chance is, right? In this is to figure out to get around this, because it has to be the way it's described in the in the spec. And so that gives them hope. One or more processors configured to receive one or more signals from at least one of the photodiodes. You know, obviously it would be nice if they receive signals from at least one of them, because, you know, otherwise what are they detecting? And output measurements responsive to the one or more signals. In other words, the signal went through the skin, saw the blood, it was reflected back, and the reflection tells us something that we can determine. The measurement's indicative of oxygen saturation of the user. Okay, so that's what they claimed. And then we have also comprising a thermistor, so also with that. And then also, they found the infringement of claim 22. That's why I'm going through all of this, by the way. So also it has to have a thermistor. Also, one of the processors are further configured to receive a temperature signal and adjust operation of the user-worn device responsive to the temperature, because apparently the temperature of the device might impact it. So it's smart enough to be able to detect heat and detect how hot the device itself is and its operating environment, and smart enough to adjust itself to deal with the heat of the things, because that's radiation too, right? Heat's radiation. So we have to have some way to detect that and some way to compensate for that. Great. And then we also have a further where the plurality of emitters comprise at least 4. So plurality just requires 2. So in earlier 19 we said plurality. So 2 would be fine. But specifically in 22 we say, how about 4? And where in each of them comprises a respective set of at least 3 LEDs. That's pretty specific, right? That's pretty specific. So not 1, not 2, but 3. And not 1, not 2, not 3 emitters, but 4. That's pretty specific. And that's what they found infringing. Okay, so obviously they can't change the hardware. They can't change the fact it has a thermistor, but they might be able to change the fact that the processor is configured to, you know, do certain things. Maybe, possibly. That's their best hope. And then we also found infringement of claim 28, which is an independent claim. A user-worn device that has a first set of light-emitting diodes, the first set comprising at least an LED configured to emit light at a first wavelength, and an LED configured to emit a second wavelength. So we have 2 LEDs, one does one and one does the other. Now we have a second set spaced apart from the first set. As we saw in the images, we know exactly what they're talking about, right? So we have the set that's by each other, right? And now we have a set that's a little further away, so they're spaced apart. Now that second set has a diode that does a first wavelength and a second wavelength. So maybe we might also be able to somehow, like, because both sets of diodes have to do first and second, maybe we can tweak the wavelengths in some ways that are not infringing. Maybe we can do that. I'm not sure the degree to which that would be medically available, but maybe there's something in the technology there. 4 photodiodes arranged in a quadrant configuration. There are 4 of them. It's a quadrilateral. It's a rectangle. On the interior surface of the user-worn device, because if it's on the exterior, it's going to be a little bit hard to detect the skin. And configured to receive light of at least a portion of the light that's been sent through the tissue of the user. Great. We want a thermometer to determine temperature, a protrusion arranged above the interior, the protrusion comprising the convex surface, a plurality of openings in the surface, extending through the protrusion aligned with the 4 photodiodes, each opening defining by opaque surface to reduce light piping. So again, we have this interior surface with these diodes, and now we're putting on top of it an opaque surface, which prevents light from coming in from the outside and also helps prevent light from coming from the light emitting sources to get into the sensors. So we have a light emitting portion and we have sensors, and now we're encasing it in an opaque thing so exterior light doesn't come in and also blinds the sensors. Cool. A plurality of transmissive windows. The sensors probably need a transparent part so the sensors can sense the light. That would be great. At least one opaque wall extending between the exterior, where the interior surface, the wall, and protrusion form cavities. The photodiodes themselves are contained within a little opaque recessed section, right? They're recessed into the opaque thing, at least some degree. So there's a little bit of a wall. It doesn't have to be a lot. Obviously, we're talking about, very small measurements here because this is, worn by a user. It doesn't have to be a lot, but there's a little bit of a shield there so that light doesn't come from the light emitting sources into the sensors. It only comes by reflecting from the interior. That seems like a good idea to do that. One or more processors configured to, and again, configured to, there's that means for language again. That's where things get really, really tricky. That's where my bills start going up a lot. You want to know where my bills start going up a lot? That's where my bills go up a lot. Configure to, oh, we're going to be here for a while. Yeah, configure to receive one or more signals from at least one of the photodiodes. Not all of them are going to necessarily work all the time, but at least one would be good. Otherwise, we have no light coming in. And calculate this oxygen sat. The one or more process further configured to, there's that means for language again, receive the temperature signal. Now we have a network interface configured to wirelessly communicate to at least one mobile phone on an electronic network. It sounds like an iPhone to me. I suppose we could prevent the watch from talking or relaying the information to the phone. So I suppose we could do that and it wouldn't infringe this claim. Now we have a user interface comprising a touchscreen display where the interface is configured to display indicia responsive of the measurement. It tells you what the result was. We have a storage device to store the result, some kind of memory, and a strap. So it's strapped to the user. All right. So hopefully I've broken down patent into something a little bit more approachable. But I think you're beginning to understand why patent law is so incredibly complicated. First of all, writing one of these things is very difficult. And that's where I came in, right? In the what we call prosecution of the patent. I'm not sure why we call it that, but that's what we call it. Maybe because we want to sound more badass. When you're working with the patent office, we call it prosecuting the patent. So that's what I did. I prosecuted patents. And so writing one of these things is a bitch. And dealing with, the prior art is a bitch because you have to figure it. You have to read everything. Here's what I did. Okay. Let me just tell you what I did. Okay. I read these things. I was part of the editors, as it were. I read these things. Someone else produced them, thank God. But I read these things and I attacked the shit out of it. That was my job. That was what I did, right? I attacked the shit out of it. So I read these things and then I read every piece of prior art cited, which can be hundreds or thousands of pages. Okay. And I attacked the shit out of that stuff. And incidentally, I got so good that I could usually do one of these things inside a day. Although electronic claims are shorter. Their patents tend to only be about 20 pages long. So it wasn't so nightmarish. But still, you had to do this. So I got so good by the end of my career, I could do it in a day. It didn't particularly hurt, by the way, that 15 years into my career, I had read so many academic papers, so many patents, so many speeches, so many things. It didn't particularly hurt that I had read so much about this technology that, I was able to kind of skim by the end and still get the point. Because, I'm king shit expert at this point. I'm king shit expert because I've spent the last 15 years of my life reading nothing but stuff in my little niche domain, right? I did computer databases and search engines. Little niche, right? Databases, search engines, little tiny niche, which is very typical, okay? So it did a database call. So by the end of 15 years, I had read so much about databases, so many books, so many papers, so many patents. I was king shit expert. So it didn't particularly hurt by the end of my career that, I knew so much that I could skim these things and do it inside a day. Yeah. Oh, Lord. Yeah. Yeah. And and then of course you have to convert English. And patent language is written in this very weird way, right? It's technically English, but it's very strangely worded English because you're trying to describe technical in English, and so if you're not used to reading it, it can be a little bit obtuse. So all right. So now we have the same exact thing we saw before. So that saves us some time. But we have a different patent. Okay. So they filed the same exact technology. They filed multiple applications to different manifestations of the invention. Perfectly proper, right? They can claim everything they have claimed. And they by law have to claim one manifestation of the invention in any particular patent. I'm not sure there's a better way to describe what I'm telling you about, but they can't in one patent describe every claim to every manifestation. They have to sort of, it's a little bit hard to convert into standard English. That's why I'm struggling. But they have to basically, they can only claim one version of the invention, right? So if they want other versions of the invention, they have to, by law, put them in other applications. This is also to save the patent office the headache, because if you have multiple different versions, it's a little bit hard for the office to deal with it because they're having to think about too many things at the same time. So in the interest of making this incredibly complicated universe a little bit simpler, we've said that you can only claim one manifestation at a time, so we don't have to deal with multiple different manifestations and have our brains explode. So here's a slightly different manifestation of the invention, which also got a patent. Same technology, different claims. Different manifestation. Not a lot different, but enough different that it justified a separate application. All right, so we see the same kind of thing, right? We see the user-worn device, the diodes, the second set of diodes. Now we have a protrusion comprising the complex surface, the epoch, the openings, optically transparent window, the processor signal to receive, the housing, and a strap of the user, right? So we have that as the independent claim. And then claim 12, wherein this invention comprises oxygen saturation. So a slightly different version of the invention. And then we have the device comprising the plurality diodes, at least 4 diodes, protrusion comprising convex surface and a plurality of holes, each hole including a window and arranged differently, one or more processors configured to receive, and where the protrusions comprises opaque material to prevent light piping. And then also we have this specific claim wherein the protrusion includes one or more chamfered edges. And chamfered means essentially it has like it's kind of like a curve, except the curve has a sharp angle. So you can also call it a beveled edge, right? So think kind of like an octagon, right? So you have an octagon, right? And it's kind of curvy, but the segments are sharp, right? So you have this sharp angled portion of the exterior, and that's chamfered, right? And the sharp angled portion doesn't necessarily need to be the entire thing, like the octagon, right? It can be a curve that then becomes straight and back into a curve. That's chamfered. Exciting. So yeah, that's what they did, and so that's what the ITC found. The ITC found that Apple did those things. And this technology goes back to 2008 because that's the priority date from the prior application. And they get 20 years. They get 20 years from the priority date. Hence, it was filed in 2008, hence it expires 2028. Regardless, incidentally, of when each manifestation of the invention is filed, right? You get 20 years from the filing date for any manifestation of the patent, right? So no matter how many applications you file, no matter how many are granted, they all run from that first filing date. So they all expire as related to this invention in 2028. Yeah. So the best hope for Apple, as I said, is in the configuration of the processor. And that's where we have to go and that's where I get paid more, because that's a means for claim. And now I have to go interpret the spec and exactly what that is and figure out how to work around that. And that's where, that's where $ go up. But that's their best hope, is to figure out how to manifest the processor to not do certain things, because then it wouldn't infringe. Yeah, so great. So that was only an hour. We actually did pretty well. We actually got through the article and explaining 2 patents in under an hour. I'm modestly impressed we were able to do that. I feel like I did a good thing today. I got done in under an hour. Wow, that was amazing. All right, so now I'll take your questions now that I've been reading and thinking about things for a while, and was kind of ignoring chat because, again, this is technically complicated, and I kind of needed all my brain power for this one. Even though I'm king shit expert, I still needed all my brain power because it's really fucking hard. So I had to ignore you a little bit, so sorry about that. Eh, Lord. Can you tell you what the consequence is? Yes. The latest versions of the Apple Watch cannot be sold anymore. Or more to the point, they can't be imported anymore, which is the same thing. Great. That's the too long didn't watch. It's the latest versions of the Apple Watch that have the oxygen sensors on them. That have the oxygen sensors can no longer be sold by Apple and can no longer be imported into the United States. So supply will drop rapidly unless they can find a solution around it. That's the too long didn't watch. Alan Parker gifted 20 gift memberships. Sandy gifted 10 gift memberships. KL Burke gifted 10 memberships. Tony gifted 10 memberships. And Susan Steele gave Czar $14. Thank you very much for all your super chat. Am I missing working as patent king shit expert? No, I am not. I am not missing it. No, I am not missing it, man. I got burned out. Hard. Again, the problem for me is patent lawyers tend to become very niche because their value as patent experts becomes more valuable the more niche they are, because no man can know everything about everything, right? So what tends to happen, and it's very common for patent people, is they tend to start out pretty niche at the first instance. And then, as they learn more and more, they gain more knowledge. So their expertise becomes more valuable. And they tend to narrow down even further, right? So they narrow down even further. And so by at the end of my experience, I was in a very little narrow slice of the universe. It's not all things. It's computer databases and search engines, not even really all that. It's some segment of that, which I can't really describe to you in words, because I can't really describe the focus of it. So let's just move past. But so you basically become more niche because you become more valuable, and the more niche you become more valuable because you're more of an expert and able to do things faster, right? So you're able to do things faster where you can do it in a day because you know everything, right? So you become valuable because you know the answer basically instantly. The problem for me was kind of exactly that, to be honest. I had nothing new to learn. either about the law or really the facts, right? I mean, again, by year 10 at the latest, I knew everything within my little niche. You know, it's 10 years of reading academic papers, patents, presentations, speeches, websites, whatever else I can get my hand on. You know, thousands, tens of thousands of patents, tens of thousands of publications. I don't even know how many pages I read by the time I got to the end of the career. It's probably 1 million pages. I don't know. It was a lot. If you told me it was 1 million pages, I'd believe you. You know, so I read so much stuff. And so there was nothing new for me to learn. And so I was unhappy. I got to the point where I was working on the assembly line and just doing the same assembly line task every single day. You know, I was on the assembly line and just doing the exact same repetitive motion day in, day out, and it crushed me. So, yeah. A court judgment on the IJ has come out. Lord have mercy. Was it anything exciting? What subject would I like to have 10 years of knowledge on? Supreme Court. Well, I probably already have it. But the nice thing about Supreme Court is I haven't exhausted my knowledge yet. Because when you're considering like all of Supreme Court, you're considering a very wide area of law, right? So, because the Supreme Court touches everything federal. So even becoming a pretty big expert on the Supreme Court as I am, I don't know everything. Because the Supreme Court kind of touches everything. It's not, the practice in some senses is a little niche, but the amount of information that's available is, you know, essentially limitless. So I'd say Supreme Court. I'd say I already have 10 years of knowledge on Supreme Court, but I'm not bored yet because there's so much stuff. If someone's getting one for Christmas, are they SOL? No. If it's already been bought, no. This does not apply to any item already sold. If you're trying to buy one right now, you know, first of all, you're kind of pushing it kind of close to the date in the first place. And second of all, supply is going to become rapidly problematic. But if you already have one, you're in the clear. They said that's fine. If I buy one abroad, assuming they continue to sell them, would I be able to bring it back? Well, technically, no. But customs would have to notice, which would be pretty hard because it looks like any other Apple Watch, right? So assuming somehow that customs could figure it out, then no. But how would they figure it out? I'm not telling you to break the law, though. Don't break the law. Yeah, Series 9 and Ultra 2 are the ones affected by that. That's correct. And this does not affect Android watches. My niche was computer databases and search engines. If it did a database call, which was both very broad applications and very narrow. So I dealt with Google and people who wanted to be Google in various manifestations. I dealt with search engines that were also more niche and specific. Think, for example, like a legal search engine, right? So it's a search engine in a limited domain. And then I also dealt with this really hyper-specific stuff that the user would never even know happened, right? Because the technology is doing the database call behind the scenes. You're not even doing it yourself. You know, you're just interfacing with something and a thing is happening. So I dealt with stuff where, you know, a user's just like using a computer or a tablet and they're just interfacing with it, you know. For example, it would be similar to like Netflix recommendation systems. I did a lot of recommendation systems like that, right? The user is watching or observing content and the system is trying to figure out what content to promote or recommend. I dealt with a lot of that shit, right? So you don't know it's happening, but it's happening, that kind of shit. And sometimes I dealt with this ultra niche stuff. Like, it was so incredibly niche. You know, it's like who would do this? You know, it's like apparently this guy, right? It's this guy. Well, it's like, why would anyone do this specific thing? Apparently this guy would. And so sometimes I'm like, I can't imagine that anyone else would want to do it this way, but you know, okay. So that's sort of what I did. I did a little bit of augmented reality because augmented reality has to do a database call, right? You're out in the world with your glasses, you know, looking at stuff, and you want projections on the glasses that you can see that are augmenting reality to give you directions. Well, in order to do that, you need to figure out where the hell you are, right? And also you need to figure out what things to put on the augmented reality display. Like if you're going to show directions, you need to be able to like get the directions, which means you need to do a database call, right? So I dealt with a little bit of augmented reality, a little bit of virtual reality for the same reason. Not much, but a little bit. If you were like hardcore augmented reality or hardcore virtual reality, that would be done by someone else. But if it was a little bit more tangential, I dealt with it. Again, it's an ultra niche thing. What else did I do? I had BlackBerry at one point before they went bust. That was cool. A lot of companies you've never heard of. I had Microsoft, Yahoo, had Yahoo a couple times, Google, IBM. IBM files a lot of applications. I think they're still the most prolific at the patent office. IBM is number one. A lot of IBM stuff. Yeah. That's what I did. Do other watch manufacturers have the same issue? I don't know. Would the patent be able to sue them as well? Is the patent owner required? No, the patent owner is not required to sue them. It's not trademarks. They don't have to sue. It's up to them. Am I a speed reader? I certainly got that way by the end. You know, it's pattern recognition. You don't even really again, it's the whole Tetris effect, Doom thing we were talking about the other day. You know, you play Tetris so much, it starts to impact your thinking. You start to see the world like Tetris a little bit. Yeah. So, you know, my brain became adapted to reading patterns. So I was a speed reader because I already knew what they were going to say. Because after a while, you know how these things are written, and you can pretty easily predict what's going to happen next. You become a human prediction engine. Fun and exciting. Yeah, when you go on a Tetris band, I dream of Tetris. Yeah. So imagine doing that 8 hours a day, 5 days a week for 10 years. Except, you know, you're reading paper after paper, patent after patent, and writing about what you've read to express opinions about it and doing it over and over and over again. Yeah, I was thinking in patent for a while there. Yeah. Did I start to dream in patent? I don't dream very much, but sometimes I did have dreams, and that disturbed me too. It's like I'm working in my dreams now. Damn it. Were there any patents that really stood out to me? The ones that stood out to me are just the most comical. Because you know the really comical ones passed the water cooler as it were. So the one that always stands out to me, because it came relatively early in my career, as just an interesting one, and also because it had really good drawings. Like you saw the drawings here, like they're really, really technical, but these drawings were more artistic, right? They're less technical, they're more artistic. Like, so they're more akin to how drawings were done in patents, like in the early 20th century, where they were more, if you go see some old patents, and you go see some old patent drawings, man, they look like works of art. They're really fantastic. We've lost something in the modern era. Like some of that stuff, like you could frame and put in a museum. It's beautiful. But I passed one that was more in that style that was relatively recently filed. So it was filed, you know, in the office while I was working. So that's why I was passing the water cooler. And as memory serves, the title of it was Burial Resurrection Machine. It was a coffin to bring people back from the dead. And it had these really kind of cool, kind of gothic images, you know, very sort of like true to type, that were kind of cool. So I liked that one. And then there was one that I saw, which was really short. It was the shortest patent I ever saw. It was only four paragraphs, including the claims. You know, the entire patent fed on the page, which was hilarious. And it was a method of something relating to love, which I can't quite remember exactly what it was, but it's like, here's how to achieve love and happiness or something. And like its entire support for this proposition. So like paragraph 1 is just the title. Paragraph 2, so it's like, you know, all of like 10 words long. Paragraph 2 is like, here's how to, you know, achieve love and happiness. Paragraph 3 is literally from the Bible, right? I forget which chapter and verse it was, but it's literally just a Bible citation. And chapter 4 was, or paragraph 4 was, I claim, you know, the way of love as described herein. And the patent office rejected for lack of utility. But I was always mad at the patent office because they missed the most obvious 102 rejection ever, right, for anticipation. I'm like, dude, he's literally citing the Bible. It's a prior publication. It's been around for a while. But they didn't make the prior art rejection. They just made the utility rejection, which made me sad. I was like, yeah, I mean, I understand the utility rejection, but like, why not the prior art one? It's in the Bible. It's been around for a while. No, you can't patent the Bible. That's the entire point. He tried. No, you can't patent the Bible. You can only, okay, we have a 1-year publication rule. All right. So first of all, if it's written by anyone else, you can't use it, period. And second of all, if it's written by you, you can only use it if it's less than a year old. Taking note that the Bible is written more than 1 year ago, you know? Yeah. Did I have to read the Bible? No. He cited it to me. It was literally in the thing. He literally cited the verse. It was his only support. I was like, I take your word that that's what the Bible says, but no, I don't have to read it because you told me what it is. It's right here. You know, and I'm like, okay, no, that's more than a year old. Yeah, so no. And then I also really like the one that was where the patent attorney asked for a reduction in fees because of the what I always call the Patent Reform Act, because I was studying it, you know, in school when it was still called the Patent Reform Act, and it has a different name now. I forget. I think it's something like the Leahy Reform Act, but I always remember it as the Patent Reform Act. Anyways, he objected to paying more fees because the fees changed as a result of the law. He objected to paying more fees on the specific ground the law wasn't valid because Obama signed it and Obama wasn't born in the US. A patent attorney submitted that to the patent office. Unsurprisingly, the patent office took the position that, you know, he's the president, so, you know, yeah. But I was like, I can't believe he had the balls to write that. The one that I personally touched dealt with Google, where they wanted to, and let me describe this as broadly as possible. They wanted to create a search engine just like Google, but in addition to getting web results, it would also get results for like your personal documents and stuff. So it would also like search personal resources in addition to the web and present them together. So I thought that was kind of cool. That stands out a little bit. Yeah. Google's implementation of it, as described in their application, was much better than Cortina. I thought it looked pretty cool. We got that one approved. I don't know if they ever did anything with it, but we approved it. Yeah. Yeah, I don't remember the verse. I remember the verse. Uh, I remember one where I like busted a guy for prior art in China, where I like really dug down and really because because a prior sale or a prior offer to sale also counts as prior art, right? Because yeah, so not only does the publication count, but the offer to sell it counts, even if you didn't sell it, and it counts anywhere in the world. And I found evidence this guy had made an offer to sell in China and asked for further information, and he gave up the whole thing. That was good. Yeah. Dealing with foreign patents was always a challenge because of the Patent Cooperation Treaty, among other reasons, right? We have this whole agreement with other countries that makes it easier for people in certain countries, principally the United States, the European Union, and Japan, and also the Korean Patent Office, right? So we have this agreement, and it's not just them, but those are the big ones. So we have this agreement that basically any patent that's granted by one of these countries gets an expedited review in the other country, and it doesn't mean that they have to grant it. And I've certainly seen situations where the US denied for its own reasons, because the law is slightly different, of course, as you would expect. And just because Japan came to their determination, we're a sovereign country, so, you know, screw you, Japan, on some level, lol. Um, so I had to deal with applications that were translated in English, and Japanese patents were always the worst because they have a different way of writing them, and they don't translate well into English, and they're hard to deal with. And I can't describe why that's true. It's just, you know, if you're dealing with the way they're written in the US, they're written in a way in the US, right? All the patent attorneys write them the same way. So they're really easy to do, you know? And but Japan, the way that they write and they think about stuff is different. And so Japanese patents were always the most tricky. I didn't like the Japanese patents very much. They probably didn't like ours. What else can I talk about? Did I ever work with CPO? Not directly, but I worked with some of their stuff. You know, I didn't directly interface with foreign offices. Um, you know, I dealt with their inventions, but I didn't directly interface with SIPO, but I dealt with some of their stuff. They were better than the Japanese. You know, the Japanese were the hardest in my experience. The Chinese were better. I dealt with patents everywhere in the world. I dealt with some, principally I dealt with a lot from Europe, Japan, and Korea, because again, they're the biggest producers by far. But I dealt with some from China. I even dealt with some from Africa on a couple occasions. Like, wow, Niger has a patent office. Who knew? That kind of thing. So yeah, I dealt with patents all over the world, but mostly European, Japan, and Korean. Japan was the worst. Canadian sometimes, yeah. The Europeans aren't too bad. The Europeans and the United States actually reached an agreement while I was still working on classification that made my life so much easier. It was so great. Like, because the United States for a long time had its own classification system, just like what pigeonhole do you put it in, right? Like, how do you classify this technology? What group of things does this belong into, right? So there was a world standard. There was a world standard which the Europeans mostly followed, and the United States absolutely did not. And so that was a little annoying because it made it a little bit harder sometimes because their classification was different than our classification, it made things a little bit more complicated. And then at some point we signed a treaty, thank God, and we adopted the same classification system. That made my life a lot easier. And then we had a whole process for reconciling our differences, which was great. So like if the Europeans and the US disagreed, there was like a whole process for like reconciling that, way above my pay grade, but there's a process for reconciling that. So we would all agree. Made my life much better. It was great. Not that we, but it was a thing. I mean, it was also understandable to some degree that we were disagreeing, particularly at the time I was doing it, because I was doing it when it was brand new, right? We had just signed this treaty. It just existed. And so, there were some learning pains at the beginning. So I assume that's gotten better. It wasn't too bad. It wasn't like we were massively disagreeing all the time. We were mostly on the same page. So it wasn't a huge deal. But I just think it's funny. Yeah, I don't know what's new on Maya. Could someone send me whatever's new on Maya on the thing on my Discord, please? Because I don't know what's new on Maya with this thing. The one that I thought got the worst rap, like, because people like send those inventions with each other. Like, can you believe someone tried to patent this, right? So every once in a while, someone tries to patent something and the press gets a hold of it and it's like, can you believe someone tried to patent this? The one I thought got the worst rap by the general public was the one dealing with a new way of putting together peanut butter and jelly sandwiches. It's like, well, peanut butter and jelly sandwiches have been around forever. Da, da, da. And I'm like, I think this is a bad rap, right? Because they had an idea about how to put them together, inside an envelope, right, inside a crust, in a way that would prevent them from, interacting with each other and prevent them from going stale. Now, you might say to yourself, there's prior art like Crustables, and maybe that's true. Maybe there is prior art. Maybe Crustables would have done it. I didn't actually get deep into it, to actually figure out whether Crustables would be prior art or not. But the idea wasn't inherently stupid. It's like, yes, it's a new way of making a peanut butter and jelly sandwich. It is an improvement upon making the peanut butter and jelly sandwich. That's patentable. Now, maybe there's prior art, maybe not, but the idea, look, hey, Trump trying to patent the peanut butter and jelly, like, you guys don't know what you're talking about. Yeah, you guys don't know what you're talking about. So I got mad. All right, I'm going to sign off for now. We'll see if we can get this Maya document, and depending on what it is, we will discuss it later. I've been on Civil Law. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.